Hi, thanks for using My Court Coach. I'm Sarah and I'll be your instructor today as we talk about the Declaration for Default or Uncontested Dissolution or Legal Separation case, also known as Form FL170. This is a form that gets submitted along with your judgment packet, and it can be confusing because it pertains to judgments that are either defaults without an agreement, defaults with an agreement, or uncontested cases. And depending on which one of those cases you fall under, you would have to mark certain boxes. So I'm going to try and go slowly through this form just to make it clear which boxes you're supposed to mark and when. To get started, you want to fill in your identifying case caption information, per usual at the top. Below that, you're going to state whether this is being submitted as part of a divorce request or a legal separation request. Below that, if you are the petitioner, you are going to mark that the information in the petition is true and correct. If you are the respondent, you're going to mark that all the information in the response is true and correct. If either of those forms have been amended pertaining to the form that you submitted, then you would want to mark the box that says amended. Below that, we identify what type of case this is. If it is a default without an agreement, mark box 4A, and you need to identify for the court if there are assets and debts to be disposed of by the court. If not, mark box 4A, 3A. If so, then you want to mark the box below that, and that requires you to also submit a property declaration. That's your Form FL160 with this that includes the assets and debts that you're proposing to be distributed to each party. If this is a default with an agreement or an uncontested agreement, you'd want to mark the box that correctly identifies the type of case. And both of these statements basically state that there is a written agreement being submitted to the court and that we are requesting the court to approve that agreement. Next, declaration of disclosure. I think this section is particularly confusing. I'm going to show pages 1 and 2 since it bleeds onto page 2. But basically, if this is an uncontested case, then you want to focus your attentions to 5A and 5D. All divorces, as we've discussed, require that there be a set of financial disclosures exchanged called the preliminary declarations of disclosure. These sections 5A and 5D have to do with the final set of declaration of disclosure forms that are required at the end of the case. Either you want to mark 5A, and that indicates both parties are complying with the requirement to serve and exchange the final declaration of disclosure forms, or you want to mark 5D, which indicates that the parties have agreed to waive that set of final declaration of disclosure forms. Sections 5B and 5C have to do with defaults. If you are proceeding by default, you are either going to mark box 5B, and that states that you're the petitioner in the case and that you have complied with your requirement to serve your preliminary declaration of disclosure in this case, and you're waiving receipt of the final declaration of disclosure from the respondent, or you are marking 5C, and you would only mark this if there was initial service done by posting or publication. But if you do fall under that umbrella, then you would mark this box, and that states that the service of the preliminary declaration of disclosure is not required, and you are waiving receipt of the final declaration of disclosure from the respondent. Next, if this is a case that deals with custody and visitation, then we are going to deal with field 6. If you are asking the court to make the orders that are included in the proposed judgment, you would mark the first box. If the information in the declaration under UCC-JEA, your Form FL105 has changed since the initial one was filed, then you would update that and attach an updated copy of that form to this, and you would mark the box that says the information has changed. If it has not, then you can mark the box that says has not changed. If there is an existing court order for custody or visitation, parenting time in another case, then you would want to mark box 6B and list the county and case number for that case. If you are asking the court to make default orders regarding custody visitation, then 6C has a space where you would describe what the current orders are, if there are any. And then 6D, you would list the facts that support the custody visitation orders that you're requesting. So hopefully there's enough space there for you. If not, you are always welcome to add a separate sheet of paper as an attachment. Next, if this judgment includes orders for child support, you would mark box 7. If there is a child support case being handled in a different in another case, or if the issue of child support is being handled in another case, you would want to mark box 7A1 and list the county and case number for that case. If you are asking the court to make an order in a default judgment for child support, and again, this is going to be your true default, not one where there's a written agreement, then you would want to mark either box 7A2 or 7A3. You would mark 7A2 if you have a child support calculation that you're asking the court to make in order. If you don't have that and you're asking the court to make an order on its own based on each party's earnings, then you would mark box 7A3 and state who the obligor or the payor is supposed to be, identify that person, and then list the facts that you are using to estimate that party's earning ability below. Regardless, so long as there's any sort of child support order, you do need to fill in 7B regarding public assistance. 7B1, if you are receiving or not receiving or intend to apply for public assistance, you need to mark the appropriate box here. If the other side is or is not receiving, you need to mark the correct box under 7B2. Field 8 has to do with spousal support. I'm going to talk about uncontested cases or where there's a written agreement for spousal support first. If that is the case, then you would mark 8D and then just reference the written agreement. If you are asking for spousal support to be ordered in a true default case where there is no written agreement, then you need to first identify what is the relief you're asking for. You're either asking for, and it can be a combination of these, by the way, whatever makes sense to you, but you are either asking the court to acknowledge you giving up the right to receive any sort of spousal support. You're asking them to reserve jurisdiction to order spousal support in the future to one or both or either of the parties. Or you're asking the court to terminate spousal support for one or both or either of the parties. Or you are asking the court to make a spousal support order. If you are asking the court to make a spousal support order, you need to mark box 8D and then the box that says spousal or partner support declaration attachment Form FL157. This is the form that's required that provides the court with the information it needs in order to be able to make a spousal support order on a default basis. If there's any other information that you think that the court needs to know in making that decision, certainly you have the right to also mark attached declaration and provide that information. 8E has to do with family support. Family support is very rare. I wouldn't worry about that. That's rarely ordered nowadays just because there are some tax implications that I'm not sure that the legislature intended for. So I wouldn't worry about 8E unless you really are including an order for family support. In that case, do mark this box. If there's any other orders you want the court to make with respect to family support, or I'm sorry, spousal support, mark box 8F, other, and describe that here. If this case involves children that were born prior to the marriage, but do belong to both parties, then you want to mark box 9 to establish parentage for those children. And if there's a voluntary declaration of paternity attached to this, to the judgment, then you would mark box 9A. If parentage was previously established in another court, pertaining to one or more of the children, mark box 9B and list where that case was heard, what county, and what the case number is. If there is a separate written agreement regarding parentage that's attached here or to the proposed judgment, mark the box below that states that. If there are attorney fees as a part of this judgment, mark box 10. And that's all you have to do if it's a written agreement. If you are asking the court to make an order on a default basis for attorney fees, you do need to include the form FL170, mark the box that states that the facts in support of this request are included on that form. If there's any other information you want the court to know about in considering your request for attorney fees to be ordered on a default basis, list those facts under other. If you are asking the court to make this judgment entered nunc pro tunc, mark box 11. Nunc pro tunc means that there was some sort of an error that caused the judgment not to be entered as soon as it could have been. It could be either a mistake, negligence, or inadvertence. If you have any of those scenarios and you want this judgment to be backdated, you can mark box 11, but that's, again, only if those scenarios are present, and then you'd have to explain why. If either of the parties are requesting that their former name be restored, then you would mark box 12 and identify the box that correctly identifies the party that's requesting the name change. Finally, this box right here includes the findings that the court has to make when it is granting a divorce or a termination of a domestic partnership status. And that is that the petitioner respondent must have lived in the state of California and the county in which this is being filed, the state of California at least 6 months prior, and the county in which this is being filed in at least 3 months prior to filing the petition for divorce or dissolution of marriage or domestic partnership, and that the judgment of dissolution of marriage or domestic partnership is based on irreconcilable differences. If this is a status-only judgment, meaning that we are only terminating over marital status, mark the box 17 that indicates that. Below that, this statement here applies only to legal separations. It's just stating and reminding you that you are still married, even though this judgment has been entered. Finally, 19, our catch-all box, other. I usually just write, if there is a written agreement, see marital agreement, or if it's a default judgment that I'm submitting, see attachment to judgment. And then sign this form, fill in your name, date it, and this form is ready to be filed as part of your judgment packet. I hope you found this helpful. Good luck.